This is part 17 of the revision lecture series on arbitration. In this video, we're going to discuss the salient features of the Arbitration Act 1940. However, before we start discussing those salient features in detail, you need to be aware of the fact that the Arbitration Act 1940 is not the only piece of law dealing with arbitration matters in Pakistan. So before we deal with the salient features in detail, I'm going to talk very briefly about the other laws that exist related to arbitration in Pakistan. So first and foremost, we're going to discuss very quickly the legal framework in Pakistan related to arbitration. So there are currently two main pieces of legislation dealing with arbitration in Pakistan. The first one is, of course, the Arbitration Act 1940, which we're going to refer to as just the Arbitration Act. And this is discussed in this video in detail. And in another video, I will talk about the other act in detail. But for now, just let's mention the name. So the Recognition and Enforcement, Arbitration Agreements and Foreign Arbitral Awards Act 2011, which in short we're going to call simply the Foreign Awards Act 2011, and this particular act is going to be discussed in another video. The focus of this video is about the Arbitration Act 1940. So let's begin with an introduction to this particular piece of law. The law of arbitration in Pakistan is of course contained mainly in this particular act, that is the Arbitration Act 1940. However, this act is a very old piece of legislation. It's not a very recent one. And if you notice the date, that is 1940, so it is a pre-partition enactment, and Pakistan adopted this pre-partition law just after independence in 1947. However, this act of course still continues to be in force. Okay, so now let's look at some of the important points related to this act. First and foremost, the 1940 Act applies only and only to civil matters, which means that any matters involving alleged criminality or any issues relating to public policy are not referable to arbitration. So in short, only matters that include civil issues are going to be referable to arbitration. And if, for example, somebody has committed some sort of crime, for example, murder or theft, then these sort of matters cannot be resolved via arbitration. Secondly, the court that has competence to exercise the various powers under the Arbitration Act is the civil court. So in other words, the competent court which can exercise the various powers that have been conferred on courts is the civil court and not the courts with criminal jurisdiction. Number 3, the Act proposes a threefold arbitration mechanism, and this is what is going to be discussed in another separate video. But for now, at the outset, just remember that the Act proposes a threefold arbitration mechanism. And by the way, just to let you know in very briefly, the threefold mechanism simply includes, number 1, those cases where arbitration takes place without any intervention from the court, and number 2, where arbitration takes place with the intervention of the court, and number 3, where arbitration is referred to later on, even though once a suit has already been filed and is pending before the courts, even that kind of case can be referred to arbitration later on. So these are the three situations where arbitration has been mentioned in the Arbitration Act 1940. Another very important point that you should know about arbitration is that arbitration has a contractual basis, and this part is included in the Arbitration Act since it says very clearly that arbitration has to be preceded by an arbitration agreement, and that agreement has to be in writing. So that was point number 4, and now point number 5 is that the decision, that is the award of the arbitrator, is binding on the parties, and this is another key point, that is another highlighting feature of the Act, that is that the decision of the arbitrator, which we term as the award, is going to be enforceable just like another court order, for example, so a judicial order, and the arbitrator's award has the same value, of course. And you have to remember that unlike the other forms of ADR which we've talked about, arbitration is the one form where the arbitrator's award is binding on the parties, so they cannot escape it if, for example, they don't like it. Okay, so this brings me to the end of this video. In summary, we've discussed 5 key points related to the Act. Number 1 was that it applies only to civil matters. Number 2 is that the competent court is the civil court. That is, the court that is competent to deal with matters related to arbitration is the civil court. Number 3 is that the Act proposes a threefold arbitration mechanism. That is, number 1, with intervention from the court. Number 2, without intervention of the court. Number 3, in a suit, that is where a suit has already been filed before the court and it's already pending before the court for decision, there can be a possibility that the parties, all of them obviously, agree that the matter should be resolved via arbitration. So even in those situations, arbitration can be used to solve a matter, that is where a case is already filed and is pending before the court. So that's the third possibility. Okay, so number 4 was that there must be an arbitration agreement in writing, and number 5, the key point was that arbitration, the award of the arbitrator, that is going to be enforceable as a court order. So enforceability is not something that you have to worry about if you are referring your issue or your matter to an arbitrator. That decision will definitely be enforceable just like any other court order. And of course, before I conclude this video, I would like to add a few comments. That is, first and foremost, the Arbitration Act 1940 includes obviously many other points, and I have only included 5 key points in this video because as the title of the video suggests, these are the few key points that you definitely need to know about the Arbitration Act. So please don't think that there are no other important points. Every particular section and every particular subsection for that matter is of course very important. However, the aim of this particular video was to tell you about the 5 main points about the Act, so that even if you know nothing else about the Act and no other important points come to your mind while you're attempting, let's say, the exam, you should remember that at least there are these 5 points that you should be able to talk about, because these are the 5 main points. And like I said earlier, if there is nothing else you know about the Arbitration Act, then at least these 5 points should be among the list of points that you know when you're preparing for an exam, and you should be able to speak or comment about the Act in light of these 5 key points. And of course, needless to say, this is not just for exam purposes. Even if you're looking at this video or watching this video in order to gain some knowledge about the arbitration law in Pakistan in general, then also of course these are the main key points that you need to know about as regards the Arbitration Act 1940. In the next video, I'm going to discuss the main steps that a party needs to take in order to initiate arbitration proceedings. That is, the next video is going to be a brief guide to the arbitration process, and of course that video is also going to be covering only the basics and mostly be talking about the basic steps that a party needs to take. In later videos we're going to go into further detail, but these first few videos are going to be discussing only the basics. So thank you for watching. I'm going to see you in my next video.